She scheduled this. There's another visit in April. So it's doubtful that Medicaid's going to have this information to provide what the final amount of the lien or any billing is, being that they're still receiving bills.
So we need to do something with the case. We've appointed the guardian ad litem, who is only allowed to get one case at a time. So she wants to get this turned. What is it that you still need to? Is there a final settlement that's been done? I guess
Yes, the case has been settled. The only thing that's prevented it from being completely concluded is she had still been treating, and we were trying to get the Medicaid lien so that we could obviously know what that lien amount is, work on any reductions, and then be able to know exactly what the minor is going to receive.
Was it a policy limits offer, or why did it settle before she was done treating?
It was a policy limits settlement
Okay.
and offer of
That makes sense.
$50,000.
Okay.
And so,
I mean, would it make sense to try to get the case proved up so the Medicaid lien doesn't keep growing?
well, the Medicaid lien is going to keep growing either way. She turns 18 on May 22nd. I mean, this could be dismissed, and we still would have our settlement that has to be honored and these items to work out. So, I mean, I don't know that we can actually have a prove up before May 27th. I guess it's possible. But as of right now, we don't have the information to be able to do that. I don't have any figures that I can recommend to an ad litem because I don't know exactly what that means.
Who's the defense attorney on this?
I'm here, Your Honor.
Okay. So what would you like to do?
Well, Your Honor, I'm open. The reason we're here is for the minor. We have already settled the case. I've already sent the documents. The only thing, like Mr. Pipkin said, is that the documents are missing the number breakdown. So if maybe perhaps we could, I don't know, I could get a release signed maybe. And then if you wanted to dismiss the case, I think you could, but as long as we at least had the release signed, then that would be great. We would have something at least on our end. But other than that, I'm open to whatever the court decides. I mean, this is really, I really don't have a say in this, Your Honor.
My client's willing to sign the release because the settlement amount's been agreed to. So that's definitely not a problem on our end. We can get the release signed this week with no problem.
I mean, the issue is that a couple issues is that the guardian ad litem needs to, since the child's a minor, the guardian ad litem now has a duty to make sure that this settlement's in the child's best interest. And so that's one issue. And the second issue is the guardian ad litem also needs to be paid for her time because she was appointed. So I just don't know when would the statute, is there a statute of limitations issue here? Like, I just don't know if you.
No, there's not a limitations issue. What we could do, since her birthday is not until May 22nd, we could move for another one of these status hearings on, maybe May 1st or after the first week of May, something like that, where we're closer to that date to see if we've gotten and received the Medicaid lien final amount and numbers.
Something that we've done before. Do you have any idea what the Medicaid lien is? Like it's under 10,000, under 5,000, anything like that?
Because she's had some continuing treatment, I don't know.
What were her original total medicals?
So,
Do you know, Ms. Segovia? Does anyone?
I don't have the medical breakdown yet, Your Honor.
There was a $53,000 bill from Methodist Hospital. It was substantial.
Okay, that doesn't help them. Because what one
But that wasn't
concept,
paid, so 44,000. I need to see if that includes the surgeon. At one point it was 44,688.
and is there UIM or PIP on this?
There is not.
So UIM, no PIP, okay. And there's no chance the defendant was in the course and scope of his employment or her employment?
Uh,
No, Your Honor.
no, no.
Okay, so it's 50 is the total amount.
50's all, yeah, 50's
Yes.
all.
It's the policy amount, yes, Your Honor.
There's no other policies or any other way to recover. I mean, what I've done in other cases, if we had some idea what the lien was, is we could put that money into the registry of the court so that we can at least, or we could hold back that amount that not in the registry of the court. The plaintiff's attorney could hold it back until the lien is negotiated, so we can at least get the prove up finished. But I don't know that that's going to work here because the lien could be, you could be in a situation where the lien is so large that you really do have to fight it.
Yeah.
I mean, I would think that you'd want to get the lien amount as quickly as you could and start negotiating that. Unless there's something I'm missing.
No, we're trying to get it as quickly as we can. Like I said, part of our problem is one of her bills were submitted, has a billing date of March 24th. I believe that was a follow-up visit with a dentist. So that's part of it.
Is that related to this accident? Did she have a mouth injury or something?
It is. Yes, Your Honor. She had a mouth injury.
Okay. Ms. Segovia, do you have any recommendations here, what we should do?
Your Honor, I have kept in touch with plaintiff's counsel and he has been diligent in corresponding with Medicaid. I've encountered the same issue in some of my own cases. Medicaid is like backed up and they have not responded. My only recommendation would be to reset the DWAP date and hope that by then we have moved further along with the lien issue. I personally have not worked on an ad litem case where we have closed it up before the Medicaid lien has been finalized. But whatever Your Honor thinks is the best thing, I will follow that procedure.
And Your Honor, if I may add, I may have trouble actually getting my claim rep to issue a check with those liens out. We usually don't issue checks with liens. So that'd be I wouldn't be able to get the money into the registry as well.
Okay. Do we want to maybe reset it to April 17th and see if we can, maybe by then you can get the Medicaid lien? Does that work for everyone at 9 o'clock?
Yes, Your Honor, that works for me.
Do we maybe consider the 24th? I'm just trying to really
That's fine with me.
increase the chances of it being productive.
24th work for everybody?
Yes, Your Honor.
Yes,
Yes.
Your Honor.
All right, Rhonda, go ahead and reset this to the 24th. Next time, let's try to have the parent and the minor on the call, even if we're not going to prove it up, so we can kind of talk. I'd like to know what they want to do too. And I would think we could prove it up, at least that they're okay with the 50,000. And then we could have them come back if there's a big issue with the lien. But look, I'd like to talk to the parent and the minor as well next time. So go ahead, Rhonda, reset the prove up. So go ahead and set it for prove up one way or the other. And we may not be able to finish it, but we at least can get it started for April 24th at 9 a.m.
Okay.
All right, guys, have a great rest of your day. Let's try to get this proved up. Okay.
Okay. Thank you, Judge.
Thank you, Judge.
Our next case is is everyone here on the Hume case?
Yes, Your Honor, Will Hamilton, here on behalf of Southfield Mezzanine Capital.
It's David Urtiago and representing the plaintiffs, Mark Holm and 5 Points Holdings.
And then did we have this posted the proper amount of time?
We did, Your Honor. Yes, it was the notice of hearing was posted on the 23rd of February. And so I believe that completes the proper amount of time.
Rhonda, can you grab Gary for me?
Yes, just.
When you posted this, Mr. Hamilton, did you put it, did you post that this hearing would be on Zoom, or did you put the physical address of the court?
I put that it would be on Zoom, Your Honor, and I actually have to correct a previous statement. The notice of hearing was posted on March 9th, but that I believe that's still under the proper amount of time.
Okay.
Yes, sir, Mr. Judge Hoffman.
Okay, thank you, Gary. Can you call the halls for DC 208631 Hume versus 5-Star Global and see if anyone's in the halls on that case?
Yes, sir. I'll do it right now, sir.
All right, thank you.
You're welcome. Got that deal? Thank you.
Okay, so let's go on the record, Tony, on DC 208643 Hume versus 5-Star Global. Counsel, make your appearances.
Will Hamilton, Your Honor, on behalf of Southfield Mezzanine Capital.
David Urtiago on behalf of the plaintiffs, Mark Holm and 5 Points Holdings.
All right, so we've called, this case is set for a motion to seal under 76A. I understand that there's been proper posting. Is that correct, Mr. Hamilton?
That's correct, Your Honor.
All right, and you in the posting you indicated that this hearing would be heard on Zoom, correct?
Correct, Your Honor.
And did you include this Zoom link?
I did, Your Honor.
Okay. Is there anybody here in opposition to sealing this motion for sealing? Anybody here on the Zoom call? Mr. Ortiago, are you opposed?
We are not opposed, Your Honor.
All right, Ms. Clark, are you opposed? I can't hear you.
I'm not here for this hearing.
Okay, so you're not opposed
Yeah.
then?
No, I'm not opposed. I don't care.
You don't care. All right.
I mean, you know.
Mr. Johnson, are you opposed?
No, Your Honor.
All right. I'm not, there's a lot of people here on the Zoom. Anybody else here that's opposed to this sealing?
Judge, the hall was called and nobody was here by that name
Okay, or for that case?
for those parties.
Nobody was here for that case, is that correct?
That is correct, sir.
Okay. All right, go ahead and you may finish up, Mr. Hamilton.
Thank you, Your Honor. As indicated, I believe by Mr. Urtiago, the motion is unopposed by any of the parties. And the reason that Southfield is moving to seal the motion is because the motion to exclude expert testimony contains significant financial information, sensitive financial information that 5-Star Global, another defendant in the case, would like to be sealed. And Your Honor, all of the procedural requirements under Rule 76A have been complied with. And if Your Honor has any questions, I'd be happy to answer them.
No, Mr. Ortiago.
Nothing from the plaintiffs. Were unopposed to the motion, Your Honor.
Okay. The court will grant the motion. There is no member of the public or any party that's opposed to it. And we will go ahead and sign it right now.
Thank you, Your Honor.
Anything else today?
That's it. Just want to say thank you to the court and the court staff for your time.
No problem. It should hopefully be uploaded by the end of the day.
Right. Thank you very much.
Thank you.
May we be excused, Your Honor?
You may be excused.
Thank you.
All right. Our next hearing is Ford versus Onsary. Are both sides here on that?
Yes, Your Honor.
All right, let's go on the record on DC 222786. Ford v. Onsary, counsel make your appearances.
Sam Johnson for the plaintiff.
David O'Dans for the defendants.
All right. This is kind of an unusual motion. Let's proceed.
Thank you, Your Honor. I agree. As the court probably recalls, you previously entered a summary judgment in this case as to the plaintiff's two property-related causes of action. One was a deck action asking the court to declare the proper boundary lines between the plaintiff's property and the defendant's property. And then if that boundary line was the way plaintiff asserted it to be, then there would be a trespass claim as well related to some concrete that was over the boundary line. Now, we have two parts to our motion. I think defendants got it right as to the procedural aspect of our motion. So I'll concede that, and I just want to focus on the law related to attorney's fees under the Declaratory Judgments Act. The old law in Texas was that a case like this may well have been a trespass to try title claim under the property code, which would not have been proper for a declaratory judgment and an award of fees. In 2007, however, the Texas legislature amended Section 37.004 of the Civil Practice and Remedies Code, adding subsection C specifically for the sole purpose of making sure that boundary line disputes can be resolved through declaratory action, and attorney's fees as a result could be awarded for such a claim. This court awarded those fees properly in the summary judgment granted to plaintiff. Defendants did not file a response to that timely and did not file any admissible evidence in response to plaintiff's summary judgment before. There was a subsequent motion to reconsider as to the fees. The court granted that, and very respectfully, I believe the court's ruling was incorrect based on the current state of Texas law on this issue. So we've brought this motion to try to get those fees back in, because this case is a boundary line dispute subject to subsection C. This is not a trespass to try title claim, Your Honor. There's been no dispute over deed history or possession of property.
I recall in the briefing that you had cited a particular case, maybe out of the Dallas Court of Appeals. Can you share screen that case?
Yes, Your Honor. Let me make sure I have the right one. I've got a few cases up here. Are you able to see that, Judge?
Yeah.
Okay. So we're looking, it's an unpublished opinion. It's Armstrong DLO Properties versus Furnace out of the Dallas Court of Appeals in 2015. Importantly, after the legislature had amended the statute. Now, one thing I want to focus on is that this case, for example, relates to a continuous strip of real property that was 16 feet wide and 200 feet in length. And so I did the math for the court. That's 3,200 square feet. but it's important that that's in the record because that's a pretty wide swath of land. The court went on to discuss this issue. Sorry, I wasn't planning on scrolling for the court today, Judge.
It's okay.
But I want to get to the important part. So this is where the Dallas Court of Appeals goes back to the prior law. This was a case out of the Texas Supreme Court that determined that substantive rights in a boundary dispute could not go under the Declaratory Judgments Act. And then subsequent to that in 2007, the legislature amended this, as I just said, so that the parties could obtain a determination under the Declaratory Judgments Act when the sole issue concerning title is the determination of the proper boundary line between the adjoining properties. And that is exactly what we had here. That's what was pleaded in plaintiff's petition. Even in one of the improper, untimely responses to the summary judgment, the defendants focused on the boundary line. Let's see. In that response, the defendant said they discussed the property pins giving, quote, some variance on the property line. They discussed in that response contacting the county, quote, to know exactly where the property line is. And that's the only thing that was addressed in the summary judgment on this particular claim. Some of the other cases cited by defendants in their response involved, again, over 2 acres of property. Another one was a 131-acre tract of land. In this particular case, I couldn't even tell you how much land we're talking about because it's just the existence of the property line. We're not talking about whether the deeds are conflicting or whether it was properly transferred over time. Purely, this is our survey based on our deed. Please declare that this is the correct line, and therefore, this is the correct subject of a declaratory judgment under the Civil Practice and Remedies Code. And as a result, the court may award attorney's fees, which were undisputed in the summary judgment phase of this case. So this is exactly the type of situation the legislature amended the Civil Practice and Remedies Code for, this exact scenario. And we think it's proper for the court to reconsider its last order regarding this issue and vacate same.
Okay, response?
Yes, Your Honor. Armstrong DLO is the controlling case out of the Dallas Court of Appeals, at least with respect to this dispute. It certainly noted the amendments to the Uniform Declaratory Judgment Act. It also then went on, after citing Martin, to sign Coinmark, where the Texas Supreme Court basically said, yes, we're aware of the amendment, but it has to be a property line dispute to apply. I would note in Armstrong DLO, in that case, the court concluded it wasn't a boundary line dispute. It was a dispute of rival claims as to who owned the property, and they actually reversed the award of attorney's fees under the declaratory judgment action in that case. In DLO, the court cites 2 cases out of the Texas Court of Appeals out of Texarkana. The first is Lyle v. Smith, which held that the plaintiff in that case was simply asking the court to find that legal and equitable title to the property was with the plaintiffs. That was insufficient under Lyle to invoke the new provision of the Declaratory Judgment Act about boundary line disputes. That's precisely what we have here. Mr. Lazaton, at the hearing on the motion for summary judgment, specifically asked this court to simply confirm that they had title to the property. The second case that was cited in DLO was Coker v. Griesendorf, a 2012 case out of the Texas Court of Appeals out of Texarkana. There, the plaintiff's claim was wholly inside the boundaries of their property, which is exactly, and there the court held that it was not available under the Declaratory Judgment Act for boundary line disputes. Again, that's exactly what we have here. Mr. Lazaton at the hearing stated that the relief being sought was for the encroachment. And I would note importantly, Your Honor, there was no response filed by the defendant, but Mr. Seraph said there was no dispute about the trespass. He admitted that there was a trespass. And in fact, he admitted that the sliver of concrete that we've been fighting over was on Mr. Ford's property. This is not a boundary line dispute case. This is a case where it was trespass. The court's already heard that, already awarded damages for the trespass. That judgment should be entered. But to now manufacture a declaratory judgment case solely for the purpose of obtaining attorney's fees, which is the lion's share of what the plaintiffs are seeking, that's inappropriate. I would also note that the El Paso Court of Appeals case that they cite, the
Can I ask a question here? Because I think this is kind of an interesting, maybe slightly gray area. So, how do courts define what a boundary line dispute is? Because I kind of agree with Mr. Oden's. I don't think there was any real dispute over this encroachment was done onto your client's land, Mr. Johnson. It's not like they're saying that the encroachment expanded the boundary. It really is an encroachment case. Are there cases that say that if you have a situation where you built onto somebody else's land, that becomes a boundary line dispute? I guess I've always assumed boundary line disputes are, I think the boundary is here and you think the boundary is here, and that would be the boundary line dispute. I don't think that's what we have here. We have a situation where they built onto your client's land, and obviously that was an encroachment that shouldn't have happened. I don't recall there ever being an argument made that there was a difference in an opinion between the two sides on where the boundary line actually was.
There was not an argument made in court, Your Honor, but that argument is what led up to the filing of this lawsuit. And in fact, that improper, quote unquote, response from the defendants sent to the court on December 2nd has a screenshot of a different alleged boundary line. And the defendants took time to talk about it and what they submitted to the court. But it shows a different line. And we've looked high and low. There is no great case. Otherwise, I would have that screen shared for the court. But here, what we do have is
Mr. Johnson, let me ask this, and because I don't know the answer. Is there anywhere in the pleadings where Mr. Oden's clients claims that there's a boundary line dispute?
I mean, there is in that December 2nd response that was sent into the court. Yes, Your Honor.
Let me see.
Now they sent some things via email to the court rather than filing. So what I don't know offhand is if this was filed or just emailed to the court.
Okay, if it's not December, let me share screen and maybe you can tell me what it is.
And I have it up. I can show Your Honor.
Well, I just want to see what's in the court's file. So
yes.
I don't see anything that is it December 2nd of 2022 as you're talking about, I assume?
Yes, Your Honor.
Okay. I don't see anything that was filed that day. Do you see anything what you're talking about?
No, Your Honor. It must be one of the ones that was emailed and unsigned.
Just trying to figure out was it in their answer? Did they say that this was a boundary line dispute, or?
As I recall, the answer was just a general denial.
Okay, so there's nothing in the pleadings that you're aware of where they actually claimed that this was a boundary line dispute.
That's correct, Your Honor, but that is exactly what's in the plaintiff's petition. So the only pleadings before the court relate not to title, but to the placement of the boundary line, and that's it.
Let's see. Mr. Oden's, do you have any cases that kind of define what a boundary line dispute, what that means exactly?
Yes, that's where there are competing claims to the property. And in this case, there was no claim made to the plaintiff's property. In fact, just the opposite. The representation was that in fact, the defendants were trespassing on the plaintiff's property. And as far as the standard is concerned, Your Honor, what the El Paso Court of Appeals said in the Eggemeyer case is that when you're trying to determine if it's a boundary line dispute, you look to what the heart of the claim is. It's a vague standard, I understand that, but the heart of this claim was not over the boundary line. The heart of this claim was over the trespass.
I respectfully disagree with opposing counsel, Your Honor. What led up to this, and a lot of this is detailed in the petition, is a history of disputes over a lot of things that really, I don't think need to get into a lot of detail today, but it includes placement of trash, parking of cars, all sorts of things right along where the two properties meet. And it's those things, including the defendant's, yes, out of court assertions that the property line was in a different place than the survey that we provided to the court. But that's what led to the filing of this lawsuit. And so the heart of this case is determining that to try to bring some peace into the neighborhood. Again, there's been a lot of other activity with other government agencies between the parties in this case. And it all arises out of the existence and placement of where is the boundary line between the parties. The other cases that were cited, Lyle and Coker, one of those doesn't even address this section of the Civil Practice and Remedies Code other than in a footnote. The other one talks very clearly about whether the pleadings were asking for a declaration that they're the owners, which is what we had in Lyle. And that's very different than what we have here, where we're just asking the court to construe where the property boundary was. Been very consistent about that.
Let me ask kind of a big picture here. This case is still open according to the clerks. What is, as we stand here today, if I don't grant this reconsideration, what is still left in the case to be decided?
Nothing.
Nothing, Your Honor.
So why is it still open?
I'm sorry. I think it's because I had actually submitted a proposed order on the motion to reconsider that would have entered the final judgment. I think the court was concerned about that order. It just wanted an order on the reconsideration. And then frankly, I was going to ask the court if you want a motion to enter judgment or we should just simply agree on the form of a final judgment. But all of the claims have been resolved.
I mean, Mr. Johnson, I fully get what you're saying here. I think it's kind of a gray area because is this a boundary line dispute? Is this, yeah, I mean, I don't know that as you said, there's nothing right on point. You know, I can't believe there's been this much fight over this small encroachment, but I'm going to, reluctantly deny the motion to reconsider. And I want to get a final judgment in the alternative, if the Court of Appeals disagrees and says that this is actually something that can be subject to the Declaratory Judgment Act, I'm going to find, and I want to include this in the judgment, Mr. Odens, that and I believe I still have kind of discretion on this, though I know there's some case law that talks about this. I'm going to find that the proper attorney's fees would be zero in this under what is the standard declaratory judge, Justin Wright or Justin, whatever it is. This case just needs to end and the parties need to move on. And so include that all in the order, Mr. Odens. I understand your position, Mr. Johnson. I think it's a well-reasoned one. I just think that the heart of this is that this was not a boundary line dispute. So you guys have a great rest of your day. Get me an order that closes the case, Mr. Odens. Make sure you share that with Mr. Johnson. Make sure you also include at the beginning that this was heard on March 27th. I'd like this order that it covers everything, including the final judgment, no later than this Friday.
All right, I'll get that over to Mr. Johnson.
Okay. You guys have a great rest of your day, okay?
You too, Judge.
Thank you so much. All right, our next hearing is problems opening this stuff up. Okay. Our next hearing is Caitlin Farrar versus, I don't know what this is, NANA.
Yes, Your Honor, we're here on that. It's a Rule 202 petition, which means that there's no defendants.
Okay, it's just the way the clerks put it in, it's kind of unusual. All right. Tony, let's go on the record on DC 22-15418. Caitlin Farrar, counsel, make your appearances.
Marianne Howland for petitioner Caitlin Farrar.
And Cody White and Scott Schneider for respondents.
Okay, let's go ahead and proceed.
Thank you, Your Honor. We are here requesting depositions be ordered in a Rule 202 petition. Our two proposed opponents are Drew Riff and Sandra Norton, who reside in Dallas. They are staff members of Parker University, which is a private university. I do have my client here to testify to meet the burden of whether or not the depositions and production of documents would benefit my client and outweigh any burden that would be on the proposed opponents to sit for a deposition. So I'm ready for her testimony whenever you are, Your Honor.
Mr. White.
Your Honor, yeah, I have an objection to any evidence being put on. We did not receive a witness list prior to this hearing. We did not receive an exhibit list prior to this hearing. So any evidence that is being proposed to be put on would prejudice our client's ability to defend themselves and act as an unfair surprise as well.
Your Honor, may I respond to that?
Sure.
We were here previously for this hearing, and counsel was made aware that my client was going to testify. And the only reason we didn't proceed at that previous hearing was because there was no court reporter. So my client is aware that, Mr. White is aware that my client is going to testify. She's the petitioner in this case. This is an evidentiary hearing, and we have no other witnesses and no exhibits. So that's why he didn't receive a witness list or an exhibit list.
Is that correct, Mr. White?
Your Honor, in the previous hearing, opposing counsel mentioned that she was going to put on testimonial evidence. I don't believe she mentioned who would be giving that testimony. So that's the reason that we're objecting to that.
Well, I would disagree, Your Honor. I specifically said my client was ready to testify, but the associate judge at the time said that there was no court reporter, so we agreed to reset.
I mean, it's the plaintiff. I don't see how you could be surprised by the plaintiff testifying. So how much time do you need on this? You only have scheduled, I think, 15 minutes. Is this going to take very long?
No, Your Honor. I believe our testimony would be about 10 minutes maximum.
Okay. All right. I don't want to keep these other folks waiting. So let's go ahead. Let's put a pin in this case right now. Let's go off the record on it. I want to are both sides here on the BBVA USA versus Mesa Southwest Management case?
Yes, Your Honor.
Mr. Wolf, are you there?
Yes, I am, Your Honor. I'm just trying to figure out my computer. Okay, yes, I'm here.
That's all right. All right, okay, so this, let's get this taken care of. My main concern on this case is it's a very old case. It's a 2020 case. It's officially 3 years old now. You guys are wanting to continue it. We have a non-jury case, non-jury setting on May 16th. Do we really need a continuance on this?
Yeah, Your Honor, I'll respond. And one of the rare, I've been working with and against Mr. Wolf for decades, and this is one of the few times we agree on something. But
okay.
Yes, sir. We're asking for the delay because, of course, we had a default that was sent back down, and so that is a big part of the time that passed. However, we had a discovery dispute, and Your Honor signed an order to compel, which I felt like was broad, but Your Honor ruled, and your ruling is your ruling. But anyway, I represent BBVA, which is now PNC Bank, and they are very thorough in their procedures. They have a specific e-discovery procedure, e-discovery teams. They've, based on the nature of the requests, I'm going to cover everything that was asked in the response. We have already, they had to go in their procedures through, I think it was millions of documents. Now, obviously, it's done by, not by humans looking through millions of documents, but I think we've already produced like at least 45,000 documents. And I don't think Mr. Wolf would dispute that. So we're just trying to get this done in an orderly manner, in the sense that we've got and I've agreed with Mr. Wolf we obviously have this agreed motion for continuance. We're looking for about a 5-week continuance, because it took us more time than I had anticipated to pull together all of these documents, which have we've had a series of productions, and so we're just thinking about it. Another, I guess, 5-week extension is what we asked for, to give Mr. Wolf time to go through the documents. I believe he wants to take at least one deposition. We've got a summary judgment motion hearing, which I need to postpone. But we're talking about 5 weeks. And again, I know it's an older case. It's a 2020 case, but then I don't want to say lost, but there was about, I don't know, a year and a half, 2 years maybe, or a year and a half at least, that this was up at the Court of Appeals. So again, it's a 5-week delay, and it's truly done so that justice can be done, to truly ask for in this, because of the documents he's got to look at. He's trying to defend his case. We reached an agreement to try to get this delay in order to allow him the time he needs to go through all the documents which have been produced. And we're seeking, I think, about 5-week extension is what it is.
Mr. Wolf, did you want to add anything?
Very briefly, Your Honor. I think it's, it may be a 2020 case, but there was no answer, and there was default judgment, and 14 defendants went to the Court of Appeals on a restricted appeal. It came down to mandate last summer because the default judgments were overturned. So, I mean, it's not a year case. It's the summary judgment's 400 and some pages. I sent discovery on October 26th. Responses were November 25th of last year. I filed a motion to compel on January 6th. You heard it on February 6th and ordered it in 14 days. There's still no order on that discovery, but Mr. Kirkendall is not someone you have to worry about that, because if you tell him to do it, he does it. It's kind of old school.
Is there an order that I need to sign on that I didn't sign?
Well, actually, the dates are all, they were supposed to be by February 20th, and I got documents last Thursday, the 4th tranche of documents. So, I mean, it was just unrealistic. And I just told him, I said, we don't need to bother the court, just move everything and get this done. And there's plenty of things I'm sure you have to deal with that are contentious. And like Mr. Kirkendall said, we've had litigation in one case for 10 years. We get along fine.
My question really is there something that I need to do? Did you submit an order that I haven't signed?
I did, Your Honor. But the dates that I submitted were consistent with what you ruled, and Mr. Kirkendall agreed, but then the logistics of it kind of blew up. And so the dates don't work.
Do you still want me to sign an order on that or not?
Yeah, because I'd like to make sure that the objections are overruled. But you don't sign the one I sent, because it's reflective of the dates that are long past.
Is there a different order that you need to send in, or?
Yeah, I'll send you one that says, Mr. Kirkendall, what's a good to say that we produce? Is that the last tranche? Is last Thursday?
I think you're going to get 1 or 2 short ones, small ones this week, and that's it. And he's got, Judge, more than 50,000 pages.
Did you just send in something that says by the end of the week and does the same order? I mean, you know what? Can you just do that?
Are you asking me?
Yeah.
Judge, I'd be happy to prepare an order and just say that all documents will be produced and objections overruled by this Friday.
Perfect.
And then if we could get, I'm sorry.
Go ahead and make sure that gets emailed to Rhonda and for her to print it out and put it in my stack.
I will, Judge. And again, what we've asked for on the trial continuance is, I think we said the week of June 24, and that was just to allow us time to do the things that we've already mentioned, and then we need to delay on our mediation. And I've got a summary judgment motion scheduled, which needs to be pushed back as well.
So how long is this case going to take to try, do you think?
Couple hours.
Okay. Yeah, then that's.
I mean, I don't know. I mean, it depends on what Mr. Wolf comes up with. He's got a lot of documents to go through. Half a day. I can't speak for Bill, and I'm not sure he's had time to go through everything to make that determination even himself. So.
Yeah, I haven't. I decided I'd do it at one time rather than do this every week and go through. You know, I'd like to try to do it with searches and you know, not spend multiple times doing this.
The reason I'm asking how long it's going to take, I'm trying to figure out when to reset this to, because if it's going to be a multi-week trial, then I don't want to set it on June 27th because I'm not sure I'll be in town the next week. But it's a non-jury, so I can't imagine it'll go that long. So we can put it on June 27th. It's fine.
All right, June 27th. And Your Honor, can we also? I will reschedule the summary judgment motion just following the procedures that the court has done. That Rhonda, by the way, Rhonda is an amazing court coordinator, and I just.
Oh, I agree. She's the best.
I've never in all my decades of practicing law in Dallas seen anything like her. I just had to give her kudos. Anyway, and then the mediation, I assume we'll also have pushed back till 30 days before the trial deadline.
That's fine with me. It's not in the continuance, but I don't really enforce anything as long as you get the mediation done before trial. I don't really care.
Okay.
Well,
Thank you, Judge.
Let me. We had that set, and we tried to get it at the last hearing early. Now it's like 2 weeks out. We'd love to not have to sit there and look at 50,000 pages and have them. I mean, our mediator Ross Stoddard.
No. Bill, I'll push it back. You and I, let's talk. We'll get a date.
You know, what I'm saying though is we've never talked about moving that.
The summary judgment hearing?
No, the summary judgment, yes, but not the mediation.
Oh, okay. Well, I mean,
we don't really want to go through 50,000 pages and take depositions if we can resolve it.
Okay. Well, again,
I'm not. If it's not agreed to, then I'm not moving the mediation day. You need to get it mediated if there's not an agreement.
Yeah. Okay.
Maybe we skip all this if we can. You know, and it's Ross Stoddard who's good.
Yeah, he is good. It's April 17th is the present deadline, Judge. I mean,
so Ross is available.
I know.
Rhonda, I reset this case to June 27th, and I just submitted the order into the queue, into Kelly's queue.
And Judge, can we get any relief on that mediation date?
If you guys have an agreement, I have no problem with it. If you don't have an agreement, then you got to go with the date that it is, unless you want a motion.
Thank you, Judge.
All right. Thank you so much, guys.
Thank you very much, John. We were excused.
You are excused.
Thank you.
Mr. Barron, Ms. Clark, what are you here for?
I am here for a case that was set on the DWAP docket, but we submitted a dismissal, and so it just needs to be signed.
What case is it? What's the cause number?
A DC 22-11753. It's still open online, and you know.
DC 22-11753. That isn't currently on the DWAP docket, but I'll pull it up.
Yeah, if you would. There's the case says it's still today, but anyway, we just need the final agreed.
Yeah, I'll do that.
Dismissal sign. Okay, that's it, Your Honor. May I be excused?
Well, let me just make sure I have it. Give me 1 second.
Okay.
And you asked me, Judge, I'm Bill's client. I'm Mesa Southwest. I represent Mesa Southwest.
Okay.
So I'm gone.
All right, great. Perfect. The case you're on is Seydoux versus Oliva. Is that right?
Yes, Your Honor.
Okay, you guys just got that into us, so I will go ahead and sign it right now.
Thank you.
I'm showing that it was signed and forwarded to the clerks. I can check with Kelly to see if she's got it, because she's probably scanning it in right now.
Oh, it is signed. Okay, I didn't see that on the system. Okay, never mind.
I didn't either. Okay, thank you. May I be excused?
You're right. It is there. It is signed, supported to the clerk. So you're good. Thank you, Ms. Clark.
Okay. Have a good day. Thank you.
You too.
Bye-bye.
Okay. Now let's go back on the record here on this 202. Ms. Farrar, if you can raise your right hand. and turn on your video. Please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? I can't hear you. I still can't hear you.
Oh,
Ms. Howland, can I just not hear anybody? I don't know.
no. Can you hear me, Your Honor?
I can hear you.
Okay.
Ms. Ferrara, I'm not sure.
Let's see. You may have to turn up your volume in your
Computer.
audio.
Now?
Yes. Okay.
Yeah, we can hear
Okay,
you.
perfect.
Okay.
All right, let's try again. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, nothing but the truth? You need to have your right hand up. Man, you have to have your right hand up. Let's try one more time. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right, let's proceed.
Okay. Can you please state your full name?
Caitlin Elizabeth Farrer.
Okay. And are you the petitioner in this proceeding?
I am.
Okay. Can you tell the court what caused you to file this proceeding?
I filed because I think that the school may have breached their contract with me and they may have engaged in discriminatory conduct against me.
Okay. And why do you believe that they may have breached their contract with you?
I believe that they have breached the contract.
Okay. What actions did they engage in that caused you to believe that?
They did not provide me with a grade appeal.
Okay. Do you believe that they filed their own policies? I'm sorry, that they failed to follow their own policies when they retroactively stated that an informal meeting was actually a grade appeal meeting?
Yes.
Okay. Do you have an opinion as to whether they breached their contract by falsely reporting non-existent allegations of violations that you allegedly engaged in?
Yes, I do.
Okay. Do you have an understanding that you and the school had an agreement that was contained in their written policies?
Yes.
And is Parker University a private school?
Yes.
Okay. Did you request your grades from this school repeatedly?
I did, yes.
And did they fail to provide those grades to you?
Yes.
Okay. Do you believe that they may have violated the FERPA law that requires them to provide your grades upon request?
Yes, I do.
Okay. And regarding your amended petition, you are asking that the court allow you to take depositions to investigate a potential claim. Is that correct?
That's correct, yeah.
Okay. And you're also asking that the proposed opponents provide documents, correct?
I am, yes.
Your Honor, may I share my screen?
You may.
Okay, I'm going to share with you your third amended petition. And I'm going to show you paragraph 24. Do you see here where it outlines the documents that you're requesting from the school? Or I'm sorry, from the proposed opponents?
Yes.
Do you see that? Okay. So this is documents related to you from August 1st of 2021 through December 31st of 2022. Is that correct?
That's correct.
Okay. Do you understand that it's possible that after taking these depositions that you still may not have a basis for a lawsuit against anybody?
Yes, I do.
Okay. What would be the benefit for you to learn whether or not you actually have the basis of a lawsuit?
If I have a claim, that way I can decide. I don't need to waste my time and money, the court's time with a lawsuit if I don't actually have a claim.
Okay. At this point, prior to taking any depositions or obtaining the proposed documents, can you prove that any of the proposed opponents actually engaged in conduct that you might have a claim against them?
No.
Okay. And regarding the proposed opponents, to your knowledge, do they have any obvious debilitating health issues?
No.
Okay. Do you have any reason to believe that sitting for a deposition would cause them any more burden than anybody else sitting for a deposition?
No, I do not.
Okay. And are you asking the court to allow you to take the depositions and obtain the documents to determine if you do in fact have the basis for a potential lawsuit such as a breach of contract?
Yes.
Okay, I pass the witness.
All right. Any cross?
Very briefly, Your Honor. Ms. Farrar, it is correct that you were granted an audience with the dean after your dismissal, right?
No.
Okay. Is it correct that Parker University, at your attorney's request, sent your grades, grading rubrics, and scan disks so that you would have access?
Not to my knowledge, no.
Okay. Would you be surprised if you saw an email from your opposing counsel containing that information?
I did receive some emails over the course of this period with some documents, but they were incomplete.
Okay, but did they contain? They did contain your grades, right?
There were some grades, but not all the grades that I requested.
Okay, and when you were a student at Parker, you did have access to your scan disk while you're a student, correct? The entire time?
Up until my dismissal, but then after my dismissal, I did not have access.
Okay, and after you got your grades back, you did receive the grading rubrics, correct?
Sorry, can you say that again? You broke up.
After you got your grades back, you did receive your grading rubrics, correct?
I did receive some grading rubrics, yes.
I'm sorry, grading what?
Rubrics.
Okay.
That's the witness now. That's all we have.
Ms. Howland, do you have anything else?
Yes, briefly, Your Honor. Ms. Farrar, did you, how many times did you have to ask for grades before you received even some of those grades?
It was several times.
Okay. Is that the only potential breach of contract that you believe the school engaged in, or are there other potential breaches?
No, there are other potential breaches.
Okay. Can you tell the court specifically what those other actions that the school took that could potentially be a breach?
So while I was a student at Parker in this particular course, I repeatedly asked since like the third day of class for additional help, and I was not provided that help at any point in time. And then also when I was dismissed from the program, not only did I have to ask for my grades several times and I wasn't provided with them in a timely manner, or they weren't all complete, I also never had a grade appeal meeting.
Regarding the grade appeal meeting, why were you unable to secure that meeting?
I reached out to Sandra Norton, who was the head of the grade appeal committee, a couple different times to try to schedule it. I never heard back from her after like filing the paperwork. And also the dean and Ms. Ragsdale. I didn't have any luck in scheduling a grade appeal.
Is that part of the school's policy, is to provide you a grade appeal?
Yes.
Is it also part of the school's policy to provide additional help to students who request it?
It is, yes.
Were there any allegations made by any of the school staff against you that were in fact false?
Yes.
Okay. And are those actions the basis of your request to depose these proposed opponents to see if there is in fact a breach of contract case?
Yes.
Ask the witness.
I guess what are the allegations that were false? So I kind of know what's going on.
Oh, okay.
And if
Yes.
this is something really private, I can take it off of YouTube.
I don't believe it's private. Caitlin, can you tell the court what specifically those allegations were made by the school staff?
There were several, but some of them were that I didn't take advantage of opportunities for help that were supposedly provided, and that I missed classes when I was in attendance. I mean, there were others, but those are just a couple.
And were those those allegations, if they were true, are those violations of the student code of conduct?
Yes.
Okay.
All right. Anything else you wanted to present, Ms. Howland or Mr. White?
Your Honor, I would just briefly state that this Rule 202 petition is just the only burden we have is to prove that the potential information that we may garner and the benefit to my client is outweighed by any potential burden for these two proposed opponents to sit for deposition. And we believe we've met that burden, Your Honor.
Mr. White?
Your Honor, I don't have any further questions, but I would like to briefly explain and go through why this petition should not be granted.
Okay.
First and foremost, Your Honor, Texas law is clear that Rule 202 petitions are not intended for routine use, and the court should deny this request for pre-suit depositions for two reasons. One, petitioner has failed to produce any evidence in support of her petition, and two, the potential benefit does not outweigh the burden or expense. Your Honor, the law is clear that a petitioner must present evidence to meet their burden. In this case, the testimony given was nothing more than just just rehashing what was in the written petition. The petitioner stated that she believed that a contract has been breached, that she believed that she may have been discriminated against, but there wasn't any evidence as to what that was, other than just belief. And for this reason, Your Honor, the court should deny this request. But even if this does constitute some evidence, the petitioner has not met her burden. And to the contrary, the expense of this procedure actually outweighs the benefit. Your Honor, it's really not clear what benefit there is of conducting this pre-suit deposition now as opposed to waiting to file suit. Petitioner mentioned that she had received her grades, that she had received her rubric, so she does have that information.
Who are the two people? Like, what are their positions within the school? Who are the two people?
The two people, Your Honor, are Drew Reif. He's the Dean of Health Sciences, and the second is Sandra Norton, and she is the appointed head of the Faculty Executive Committee. And again, there wasn't any evidence, and it's also unclear as to why these two respondents could provide information. And also, we just don't know what information she's seeking. I mean, she mentioned that she believed she had been discriminated against, but did not point out why these two people could provide any information that would be a benefit to her. We don't know if these people have information about that. We don't know if they're the proper ones to do so. In addition, Your Honor.
So if I understand, I'm just trying to make sure I understand all this. So I understand, Ms. Howland, what your position is, or your client's position is, that if I'm kind of getting it, is that she should have been provided the right to an appeal, or she should have been provided like basically a hearing within the school under their rules. Is that correct?
Yes, that, and even though they eventually produced her grades once I came on the case and she had to retain an attorney, they did violate, or we believe they violated FERPA in their own contract by not providing her grades. So we do believe she may have a breach of contract case there as well. The other issue would be not being provided aid when requested, which would be a possible breach of their contract. Again,
Did you say aid, like student financial aid?
assistance, I'm sorry, assistance to the student. As part of their contract, they do provide assistance to students in class as requested, if the student requests it. And they
I'm not sure what you mean by assistant, financial
no,
assistance
I'm sorry,
or
Your Honor. Academic
tutoring?
assistance, like tutoring. Yes.
Okay.
Yes.
Why was she kicked out? Were her grades not high enough?
It was her grades, and then she was unable to appeal her. So most universities provide the opportunity to appeal your grades. And what they did was met with her informally, had a discussion with her, and then later said that was your grade appeal. So that's a violation, in our opinion, of their contract, but we need more information to understand why that meeting was informal or named an informal meeting at the beginning, and then later designated as a grade appeal. So at this point, what we have to do is put on evidence, which is what my client did, about what she thinks, what kind of claims she thinks she might have, and the information that she needs in order to prove those claims. We don't have to prove those claims today.
Right.
So
What I'm trying to figure out is, and why I'm a little concerned about this 202, is that it seems like your claim kind of boils down to she wasn't provided an appeal, but what would a deposition, what does she not know about that topic? Like either she had a hearing or she didn't, I guess are you trying to figure out what allows them to call this informal meeting a hearing? Is that?
yes, and we're also trying to determine whether those false allegations about her missing classes or not taking advantage of the tutoring that they alleged led to a breach of their contract with her, or whether or not that also influenced her dismissal. And so we're trying to determine
where they got the information that she didn't take advantage of the tutoring
exactly.
Okay.
And she did state, Ms. Norton, one of the proposed opponents, is one of the people that she met with who has information about this, and she was her point of contact. Ms. Norton was her point of contact about a grade appeal. So we're trying to determine whether or not Ms. Norton has that information, or if she doesn't, then she could at least give us information about who we would need to get that information from. So as it stands right now, we don't have enough for a breach of contract case, but we believe that we could if we were able to depose these people. And that's all that we have to do, is prove that the benefit, instead of running to the courthouse with a breach of contract case that may or may not be dismissed for lack of evidence, we believe that we need some more information to proceed.
And that's from Ms. Norton. Is that the one who's the dean?
She's the head of the faculty, and then Dean Reif is the other person that my client mentioned in her testimony that she did have contact with, who is the other proposed opponent.
Your Honor, what her claim boils down to is that she claims that she did not receive an appeals hearing. Our position is that she did receive an appeals hearing, but if that's the entire basis for her breach of contract claim, then it's not clear what else she needs before filing suit. I mean, any other information can be obtained just in the normal course of discovery in a lawsuit, but it seems that instead of determining if a viable claim exists before filing suit, the petitioner wants to ensure that she can prove her case rock solid before filing suit, and that's just not what Rule 202 depositions are for. I mean, they're not routine use. They're not to find evidence to make sure you have a rock solid case. They're to determine if you have a viable case, if that's the basis. And if that's the only burden, Your Honor, then
where is it within the policies that says that they have? I'm not suggesting there isn't, but where within the policies does it say that she has a right to an appeal?
So it's in the tuition agreement and then the student handbook, where it outlines the appeal process. And so we believe that they didn't follow that, and then they kind of retroactively.
It actually details what the appeal process is supposed to be.
Yes.
and you're saying they didn't follow any of that.
That's our position. And obviously, if Mr. White's position is that they did follow it, then I do think some investigation needs to occur to see if my client actually should spend the money to file a breach of contract suit. So this is, and I don't agree that the Rule 202 is only to prove if there might be a claim or to prove if we have a solid claim. There's no discernment in Rule 202 about that. It's just whether or not we can investigate potential claims. And there could be other claims that come up through our investigation that we don't know about right now. But that's the whole point of a Rule 202 suit, is to allow us to do some pre-suit discovery so that we're not wasting my client's money, the school's money, and the court's time.
All right, what I'm going to do is I'm going to allow, sorry, I should have written this down, who the names are, not the dean, who's the other one?
Sandra Norton.
Now, Miss Norton, I'm going to allow Miss Norton to be deposed. I'm going to allow documents related to any documents that she relied on in making the determination that Miss Farrar, and that would include anything that indicates she didn't take advantage of the tutoring and that she missed classes. So if there's something the registrar, it showed that she missed classes. I don't know how they keep, the records like that, but any records affiliated with that. I really don't think you need, and then anything about any documentation about any appeal that took place in this case. So what is the documents they're relying about the appeal?
Okay.
Does that make sense, Mr. White? Do you understand what the documents are?
I think so, Your Honor. Are you saying documents related to granting her an appeal, essentially?
Just anything that relates to her appeal. So if she sent an email and didn't show up to an appellate hearing, or anything related to the appeal at all. So any emails you received, any emails that were exchanged internally. Like, for example, I don't think this happened, but let's say it did. She sends an email to the dean and says, I don't like Miss Farrar for whatever reason. I don't think we should give her an appeal. Then that document needs to be produced. Or if she sent an email to Miss Farrar that says your hearing is at 3 o'clock on Friday, and then Miss Farrar didn't show up. You know what I mean? Anything that's related to the appeal in any way. That doesn't mean that you have to produce all the policies and procedures about appeals if they're available to Miss Farrar, but if there's some internal policy that she wouldn't have access to, she would need that. Does that help clarify it, Mr. White?
It does, Your Honor. And Your Honor, just if I may, I know you said that you're gonna grant a deposition for Miss Norton, but if I may, I still don't think that
I don't need you to re-argue it. I've already ruled. So if you keep arguing, I may, decide to order both of them. So take the win. So how long do you think you would need for this deposition, Ms. Howland?
I think that the deposition itself wouldn't need to last more than 3 hours. And then, Your Honor, I just wanted to clarify documents also related to the allegations of missing class and or not taking advantage of tutoring. Yes. Okay. And what about any documents related to failure to produce grades to her upon request? Because that's one of our breaches that we think may have occurred.
Okay, any emails related to Miss Farrar's request to have her grades? I'm a little confused. Did they not give her grades? Is that what you're
correct, Your Honor, until she hired me, and then we made 2 requests, and then we got some of the grades, but not all of them. So that's where
she didn't get like a report card or anything like that, like you would in most schools. Or
I do believe she got her end of the year report card, but not her specific grades for specific exams per her request.
Okay. Okay, that as well then.
Your Honor, may I just briefly address one question? in terms of the duration of the deposition, 3 hours seems a little long, especially given the narrow issues here, that a lot of this will be resolved with the document production. Can we have something in the way of a more reasonable restriction about the
Yeah, I was
duration?
thinking 2 hours, so we'll go with 2 hours.
Okay.
Understood, Your Honor.
Your Honor, may I say something?
If your attorney thinks it's a good idea.
I don't usually think that's a good idea. I'm sorry. We can talk afterwards, Caitlin, okay? It's
Okay.
usually better not to.
Okay, anything else, guys?
I don't think so, Your Honor. Oh, yes, Your Honor, there are,
Get me an order on this that says
Okay.
that this was heard on March 27th, 2023. Share that with Mr. White. Hopefully you can get it agreed as the form. Get me this order no later than this Friday.
Okay.
And then I'm sorry I interrupted you. You were going to say something else.
Yes, there was a motion to transfer venue on file that was filed by the proposed opponents for some of them who do not live in Dallas County. And I just wanted to make sure that I believe Mr. White said he was going to submit the orders for signature last time we were here. And I just wanted to make sure that we got on record that we are all in agreement to transfer that. And if you don't mind signing those orders at the same time with this other order.
Transferring what? Transferring the case.
There's So part of the case needs to be transferred to Tarrant County and then Rockwall County because the deponents, other proposed deponents don't reside in Dallas County. And so we agreed
202, it has to be sued where the opponent takes place.
where the witness resides, even though the actions took place in Dallas County, it's where the witness resides. So that's why it's necessary to transfer just for those proposed opponents. And we agreed last time we were in front of the associate judge, but we just wanted to make sure to get that on the record today that we were all in agreement.
So you would have to sever this out and send, I'm a little unclear how you're going to do this. You're going to sever those claims out and send them to other counties. Is that the idea?
Yes, Your Honor. So we would transfer to Tarrant County, the 3 who reside there. And then I believe 1 resides in Rockwall County. And so Mr. White has drafted the proposed orders and I think you filed them, but I just wanted to make sure that Your Honor was aware of them.
Mr. White.
There's a proposed order on file, Your Honor. I do remember we briefly discussed this the last time we were on.
Let me see if I have it. I'm a little concerned about this. I don't know that I would have agreed to do that. Order, the wrong case. Let's see. Okay.
Your Honor, I believe it was filed back in December, if that helps.
Okay, see. Yeah, this order is not something I would sign. I apologize. You would, first off, I need to check with the clerk to see if we can even do this, but it would need to have a section in here about a new cause number, payment of transfer fees. This order is not sufficient. I'm not saying that the relief isn't sufficient, but that order is not sufficient because you need to have a section that talks about the payment of transfer fees, a payment of assignment of a new cause number, all this other stuff. And so, because this would need to be severed out and sent to these other counties, I can't just transfer part of a case without a severance. And so, has there even been a severance requested?
No, Your Honor, what I can do is draft that proposed order and draft an agreed motion to sever if that works. And then we could get that all to you this Friday if that is
Mr.
sufficient.
White, you're in agreement to this?
I I suppose so, but I think at this point in the case, it's kind of a moot point because amended petitions have been filed removing these deponents as parties. So I think it's kind of a moot point at this point to sever and transfer since they're no longer named deponents.
Your Honor, the
Let's just do this. 'Cause I really have a question about if this is the correct procedure. I've been doing this for 17 years. I've never done anything like this. I'm not saying you're wrong, and I'm not saying the associate judge was wrong, but if I'm going to sign something, I want to hear briefing on this. I don't think this is the right way to do it. I think that you should have filed separate lawsuits in each different county if you really wanted to take the depositions that way. I don't know that I can. I guess I theoretically could maybe sever out portions of the claim and then transfer it, but the clerks are going to want to know what are they supposed to transfer, what they're not supposed to transfer. You got to think about this logistically, and I would need to meet with the clerks. This is not as easy a process as you're kind of making it out to be. So
yeah, and I can do that, Your Honor. I could just file separate petitions. I would just ask that the court because we were unaware of where the witnesses resided when we filed the petition, and we filed it in Dallas County where the action took place. I would ask for cooperation from opposing counsel on getting these other proposed opponents served and making sure we have their proper addresses so that I can file petitions in the counties that they actually reside in.
Your Honor, in our first response to this petition, we said where they lived. I believe we put down the counties they live, but
we need addresses unless you're going to accept service on their behalf.
Miss Allen had no problem serving them at Parker University where they worked. They were all served with citation and with citation of this case. So I wouldn't imagine that it'd be a problem serving them again since they've already been served.
I mean, Mr. Watt, I would suggest maybe you just agree to accept service on the other cases if you've already represent them. But anyway, that's something you guys work this out however you want to do it. If you want me to sign an order on this transfer, I want to have a motion, I want to have a severance, I want to have a hearing, I want to talk to the clerks to make sure this is done correctly. So just transferring part of a case, if someone had signed that order, I would bet you money that the clerks would have closed this case entirely, and then you'd have to do a reopen. I mean, it's not as simple as kind of how that order. It's just not how this works, and so. But anything else, guys?
I don't think so, Your Honor. Thank you.
Get me an order by Friday. You guys have a great rest of your day.
All right. Thank you, Your Honor.
Thank you.
Still on YouTube.
I thought I turned it off. Oh yeah, let me just look at something. We have one more hearing at 11. It should be kind of short. I'm just gonna leave YouTube on for now, and we'll re-sign on at 11.
Okay, Judge.
One
Good
second.
morning.
Oh, good morning.
Are you here for the Crawford, Wishnu, and Lang PLLC versus American Teachers Retirement Services case?
Yes, Your Honor.
Are we anticipating the other side to show up for this?
We discussed the hearing date and time. Since then, I hadn't heard anything, but he indicated that this was an available date and time.
Okay, we'll wait for a second. It looks like you did 2 proposed orders, is that right?
We did a order confirming the award or the application, and then the entry of final judgment separately.
Okay. We'll give them a couple minutes just in case. All right, let's get started. Tony, you ready?
Yes, Judge.
Let's go on the record on DC 231295. Crawford, Wishnu, and Lang PLC versus American Teachers Retirement Services LLC. Counsel, make your appearances.
Allie Olinger for applicant Crawford, Wishnu, and Lang PLLC.
And as I understand it, you put the opposing counsel on notice of this hearing. Is that correct?
Yes, Your Honor.
And I didn't see a response filed, so you may proceed.
Your Honor, this is on an application to confirm the entry of an arbitration award against American Teachers Retirement Services. By way of brief background, CWL represented American teachers in litigation pursuant to a engagement agreement for an hourly fee that was entered by the parties in September 2020. That engagement agreement contained an arbitration clause. Over time during the litigation, American Teachers stopped paying its legal fees and started to incur a pretty substantial balance. CWL made multiple efforts to resolve the matter, including offering discounts and reduced amounts on the total balance. Eventually, CWL had to initiate arbitration against American Teachers. Judge Ashworth was the arbitrator in that matter. The parties participated in the arbitration process by scheduling order. My recollection is that American Teachers didn't file anything until the weekend before the arbitration hearing, but they did file a response. American Teachers participated fully in the arbitration proceeding in front of Judge Ashworth, lasted the majority of a day. Each party presented testimony and evidence. And then following the hearing in front of Judge Ashworth, the parties were invited to submit post-hearing briefing. Both sides did submit post-hearing briefing. And I believe the initial award by Judge Ashworth was issued December 7th, 2020. That award omitted interest, which was requested by CWL and undisputed by American Teachers. So pursuant to a JAMS rule to correct the final award, CWL submitted a motion to correct the award to include interest. Judge Ashworth did then issue an amended award that provided for interest, but was, other than that, substantially unchanged. Then following the entry of the amended final award, CWL made a demand for payment on the final award to American Teachers. That went ignored, and following that, CWL filed this application with your court in January of this year. To date, American Teachers has not responded to the application, has not filed any motion to vacate, modify, or correct the final award. No such statutory basis exists to do so. And we request that this court confirm the final award entered by Judge Ashworth and entry of judgment upon same.
Okay, the court will grant both, I guess, the order to confirm arbitration, and will sign the final judgment in this case. Thank you so much, Ms. Olinger. Olinger, is that how you say your name, ma'am?
Olinger.
Olinger, so sorry.
No worries. No worries. Thank you, Your Honor.
You have a great rest of your day, okay?
You too.
Thank